Welcome to SCOTUScast, Recklessness and Misdemeanor Crimes of Domestic Violence Edition. Thank you for tuning in. On June 27, 2016, the Supreme Court decided Voisine v. United States. Stephen Voisine was convicted in 2003 of assaulting a woman with whom he was in a domestic relationship, a misdemeanor violation of a Maine statute. In 2009, Voisine turned a rifle over to federal officials who were investigating him for a separate alleged crime. When investigators discovered Voisine's 2003 misdemeanor assault, they charged him under 18 U.S.C. section 922G9, which makes it a federal crime for a person who has been convicted in any court of a misdemeanor crime of domestic violence to possess in or affecting commerce any firearm or ammunition. In turn, a misdemeanor crime of domestic violence is defined in section 921A33A as an offense that, 1, is a misdemeanor under federal, state, or tribal law, and 2, has as an element the use or attempted use of physical force committed by a current or former spouse, parent, or guardian of the victim, or by a person in a similar domestic relationship with the victim. Voisine challenged the section 922G9 charge, arguing that under his main conviction, offensive physical contact, as opposed to one causing bodily injury, was not a use of physical force, and thus not a misdemeanor crime of domestic violence, within the meaning of section 921A33A. The district court rejected this argument, and Voisine pled guilty on condition that he be able to appeal the court's ruling. The U.S. Court of Appeals for the First Circuit affirmed the district court's judgment, but the Supreme Court subsequently granted Voisine's petition for certiorari, vacated the First Circuit's judgment, and remanded the case for reconsideration in light of the intervening 2014 Supreme Court decision, United States v. Castleman. That decision held the requirement of physical force satisfied, for purposes of section 922G9, by the degree of force that supports a common law battery conviction, but it did not resolve whether a conviction with the mens rea of reckless as under the Maine statute would qualify. On remand, the First Circuit again rejected Voisine's challenge and held that his main conviction qualified as a misdemeanor crime of domestic violence. The Supreme Court again granted certiorari and affirmed the judgment of the First Circuit by a vote of 6-2. Justice Kagan delivered the opinion of the court, which held that a reckless domestic assault qualifies as a misdemeanor crime of domestic violence that prohibits firearms possession by convicted felons under 18 U.S.C. section 922G9. The majority opinion was joined by the Chief Justice and Justices Kennedy, Ginsburg, Breyer, and Alito. Justice Thomas filed a dissenting opinion, in which Justice Sotomayor joined as to parts 1 and 2. To discuss the case, we have David Kopel, who is Adjunct Professor at University of Denver Sturm College of Law. As always, the Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker. And now, Professor Kopel.
Federal law prohibits the possession of firearms or ammunition by certain categories of prohibited persons. Among them is any person who has been convicted in any court of a misdemeanor crime of domestic violence. 18 U.S. Code, Section 922G9. This category was added by Congress in 1996 following the homicide trial of O.J. Simpson, who had never been convicted of anything before he used a knife to murder his former spouse. The statutory definition of a domestic violence misdemeanor is any federal, state, or tribal misdemeanor conviction that involves a perpetrator and victim in certain domestic relationships and which has as an element the use or attempted use of physical force. 18 U.S. Code, Section 921-33A. In Voisine v. United States, the Supreme Court faced the question of whether the prohibition applies to a person whose conduct had been reckless rather than intentional or knowing. Does the phrase use or attempted use of force encompass reckless behavior? In a decision announced on June 27, 2016, a six-justice majority led by Justice Kagan decided that convictions for reckless conduct do trigger the federal ban. Justice Thomas dissented, joined by Justice Sotomayor. They argued that the statute was at best ambiguous, so pursuant to the rule of lenity, the statute should be construed in favor of the defendant. In Part 3 of the dissent, which Justice Sotomayor did not join, Justice Thomas suggested that a lifetime ban on the exercise of a constitutional right because of a misdemeanor conviction violates the Second Amendment. This was not a question which the court had decided to hear. The grant of the cert petition was solely on statutory interpretation. However, an amicus brief from Gun Owners of America had addressed the Second Amendment issue, and Justice Thomas raised it at oral argument on February 29. The 9 questions from Justice Thomas that day were the first since February 22, 2006, over 10 years before. Coming 16 days after Justice Scalia's death, the oral argument began a new phase of loquacity for Justice Thomas, relatively speaking. Media reporting of Voisine incorrectly claimed that the Supreme Court upheld the constitutionality of gun bans for persons convicted of domestic violence. Although the Second Amendment had been raised in the cert petitions, the sole issue on which cert was granted was whether the federal statute encompasses reckless conduct. In 2004, Stephen Voisine had pled guilty to misdemeanor assault of his girlfriend. In 2008, William Armstrong pled guilty to misdemeanor assault against his wife. Both crimes occurred in Maine. The Maine assault statute, like many other state misdemeanor assault statutes, makes no distinction between intentional, knowing, or reckless conduct. Later, Voisine was found in possession of a rifle after he shot a bald eagle. When Armstrong's home was searched for drugs, 6 guns were discovered. After being indicted for violating the federal firearms prohibition, Armstrong and Voisine pled guilty conditionally, thus allowing them to preserve their arguments on appeal. The First Circuit affirmed the convictions of Voisine and Armstrong. That decision created a circuit split with the Ninth Circuit. The Supreme Court had explicitly left the question open in the 2014 case United States v. Castleman. Voisine and Armstrong filed a joint petition for certiorari, which was granted. Justice Kagan's majority opinion agreed that for there to be a use of force, there must be a volitional act. But, said the majority, recklessness was sufficiently volitional. For example, a husband throws a plate at a wall a few feet away from his wife's head. Although he did not want the plate to strike her, he recklessly created a risk that she would be struck by broken shards. Here the court cited dictionary definitions, that to use something is to employ it. The court contrasted a reckless act with a mere accident, for which the actor's state of mind was only negligence. The common law did not recognize recklessness as a mens rea for criminal assault, but the 1962 Model Penal Code did, and its definition was adopted by the majority of states. In the 2014 Castleman case on the meaning of force in the domestic violence federal statute, the Supreme Court had relied on the common law. But according to Justice Kagan's majority, that was no reason to use the common law, rather than the Model Penal Code, for the meaning of use in that same statute. According to Supreme Court precedent, lower courts cannot examine the facts of a particular domestic violence conviction to determine if the defendant had acted intentionally or knowingly. Rather, lower courts must use the categorical approach and determine if the state statute includes all the elements necessary to fit the federal statutory definition of a crime of domestic violence. For example, a state statute which said that domestic violence includes physical assault or insulting language could not be the predicate for the federal domestic violence gun ban. Insulting language is not within the scope of the federal statute. If the Supreme Court had ruled in Voisine's favor, then domestic violence convictions from many states would no longer be firearms disqualifiers, since those state statutes for misdemeanor assault make no distinction between intentional, knowing, and reckless misconduct. Congress must have known about the details of state laws when it legislated in 1996, said Justice Kagan. If those states were excluded from the federal law, that would substantially undermine the operation of the federal statute. Significantly, the majority limited its results solely to the gun control statute at issue in Voisine. Another part of the United States Code has a general definition for crime of violence, which is very similar to the use of force language at issue in Voisine. But the majority expressly did not decide whether the nearly identical language in that general statute also covers recklessness. Similarly, in the 2014 Castleman case, the Supreme Court construed force in the gun ban statute to include any offensive touching. But in the other, broader statute, force has been construed by the lower federal courts to mean violence, not merely offensive touching. In dissent, Justices Thomas and Sotomayor invoked the rule of lenity. According to that long-standing rule of statutory construction, ambiguous criminal statutes must be construed against the government. The majority retorted that the rule of lenity was irrelevant, since the statute was perfectly clear. The majority made the same point about the doctrine of constitutional avoidance, that ambiguous statutes should be construed so as to avoid potential constitutional problems. Here, the lifetime ban on a constitutional right because of a misdemeanor conviction. The majority's point was well taken, if one believes that the statutory phrase about use of force obviously incorporates the common law definition of force and the model penal code definition of use. The dissenters said that in the dictionary, to use something is to employ it to accomplish a goal, because use is inherently volitional, not reckless. For example, in the 1995 Bailey v. United States case, the court held that use of a firearm in a crime should be construed to mean active, intentional employment of the firearm in a crime. It does not include recklessly leaving a firearm in the trunk of a car, even if the firearm accidentally discharges when the car is jostled in the course of a crime. The dissent agreed that the majority's hypothetical angry plate thrower who wanted to frighten but not injure his wife had engaged in a use of force, namely against the plate. If the plate thrower's wife were injured, that would be a common law battery by the doctrine of transferred intent. When the actor has engaged in inherently wrongful and illegal conduct, the plate thrower intentionally used force and recklessly created a risk of injury. But, said the dissent, use of force against an individual does not include nonviolent reckless acts that cause physical injury or an offensive touching. As the dissenters pointed out, and the majority did not dispute, the majority's interpretation means that a reckless driver who slightly injures a family member is guilty of domestic violence and is banned from gun possession for the rest of his life. Part 3 of Justice Thomas's dissent addressed the Second Amendment, and this part of the dissent was not joined by Justice Sotomayor. "We treat no other constitutional right so cavalierly," he wrote, "because the Second Amendment is the only right that may be prohibited for life based on a misdemeanor conviction, let alone with a mens rea of only recklessness. Indeed, the domestic violence prohibition can arise from state statutes where the maximum punishment is a fine and the defendant has no right to a jury trial." At oral argument, the attorney for the government was unable to provide any examples of mandatory lifetime loss of a right for a misdemeanor. According to Justice Thomas, in construing the statute before us expansively so that causing a single minor reckless injury or offensive touching can lead someone to lose his right to bear arms forever, the court continues to relegate the Second Amendment to a second-class right.
Thank you for listening to this episode of SCOTUScast. For more episodes of SCOTUScast, as well as audio and video of past Federalist Society events, please visit our website at www.federalistsociety.org/multimedia.